Court of Appeals Division 1 is now in session.
Thank you. Please be seated. Good morning.
Good morning, Judge.
Morning. We are here for oral argument in case number CV19-0851. This is Miller et al. Appeal. A couple of housekeeping items before we get started. In more normal times, we'd invite you to stand at the pulpit there as you present your argument, but because today we are not in those times, we'll invite you to just stay seated where you're at throughout argument. As you can see, our panel is physically distanced and we have our masks removed so that we can communicate with you better. Because you're also physically distanced, if you would like to, you can remove your mask during argument. If you're more comfortable keeping it on, then please feel free to keep it on. These proceedings are being video and audio recorded and live streamed, so we ask counsel to please identify yourself and your client at the beginning of your argument. Each side will have 20 minutes. Appellant's counsel is responsible for watching the clock to reserve a portion of that time for rebuttal if you desire. And you might need to stand up out of your chair to be able to see that clock there. So, also, please keep in mind that we have read the briefs and have conferenced the case this morning. With that, counsel, you may proceed.
Thank you, Your Honor. It's been a while since I've had a appellate court oral argument.
And you can stand or you can sit. Whichever one you'd like is fine.
I'd rather stand.
Okay.
My name is Jim Andrews, a.k.a. Lloyd J. Andrews. I represent the defendant Hill, the appellant in this matter. I would like to reserve 5 minutes for a rebuttal. That's what we used to have to do, but now I have to watch the clock, I understand?
You can keep track of it yourself.
Okay, that's fine. I just want to make sure I know the rules.
Yep.
This whole case is unfortunate. It's a battle between two neighbors. It's been going on for 6 years. It has never been resolved, although we've had many attempts to try to resolve it, eventually ending up in trial. And you've got the transcripts of the trial. You've got our opening briefs and my reply brief. The position that we have taken is that the jury verdict of no breach of contract and no tort liability for Ms. Hill is supported by the evidence. And that's our opening.
Did your client ever assert in any way below that she was not at least jointly responsible for the repair? Did she ever say, oh no, they were the ones who did the damage, so I shouldn't have to pay?
Yes, there was discussion about that to some degree. It has to do with the dry lock, and I mentioned that in my reply brief. And we, on numerous occasions, indicated that because of the age of the wall and the way it was originally constructed in the early 90s, time has a factor. So we have gone, and I've given you the schematics. It's exhibit number 55 from our estimator, Mr. Keith.
Right, but what I'm asking is, did you argue to the jury or assert in a pleading in some way, I should not have to pay a dime?
No.
Okay.
I did argue no breach of contract, no tort liability.
So you conceded that if the wall is damaged, you conceded the wall is damaged, correct?
Yes.
And you conceded that if the jury found that your client, Ms. Hill, was not responsible for the damage, you conceded she was responsible for at least sharing in the cost to repair.
Well, I can see that in the arguments that are being presented now, yes. And the jury verdict forms, verdict number 2, did have that allowed to the jury, but they never accepted it, never went and filled that part out. And the critical point in my mind is that what are we doing for these people, his client and mine, if the wall isn't repaired? And the way the jury left it, it's not repaired. So that goes back to the argument of apportionment. That doesn't mean there has to be a new trial on all grounds. And I've cited a case, Sade versus Stanton, which talks about that from the Arizona Supreme Court. It's in my reply brief. And it says, if you can separate the two, damages and liability, in this case, apportionment and liability, then have the trial on just one of those. And that makes sense here, because the jury was quite clear, Mrs. Hill is not tort or contractually liable.
So if we were to accept what you just said, what would your remedy be at that point? Remand back to the trial court for solely a trial on apportionment of damages and damages?
Exactly.
Okay.
All right.
And I want to go back and make sure I understood what you said about the forms of verdict. You said there was a form of verdict 2. I didn't see in the record, and I could be wrong, where there was an apportionment request in the verdict form or a damage calculation in the verdict forms after apportionment. Is there, and why don't you look for that later and let me know on rebuttal.
All right. I will do that. Although I do have it already, because I knew that was going to come up, Judge.
Great.
Okay. And it is the verdict form that has, well, I don't think I can approach.
You
can read it to us.
You
Okay.
can just read it to us.
Okay. It's we, the jury duly impaneled and sworn in the above entitled action upon our oath do hereby find in favor of the Millers, I'm abbreviating, and find the full damages to be X. We find that Cheryl Hill is liable for breach of contract, and then there's percentages. So,
Okay, but they had to first find her guilty of breach of contract. They couldn't just say, the wall was damaged through no fault of anybody's. It could be poor building, it could be the weather, it could be a lot of things. But this wall is damaged, and y'all in your CCNRs must apportion the damage amount between you in equal proportion to your percentage interest.
right.
There wasn't that option.
There was not a
Okay.
jury verdict that says that, Your Honor. You're
Okay.
absolutely correct. No one was never offered by either side.
All
Why
right.
not?
Well, I don't know the answer to that. As the defendant, I wanted 0-0, no tort, no contract, and that's what I got. The argument now that there should be an apportionment is of
Well,
later development.
but I think even during, and you know the record probably better than I do, but even during your presentation, it didn't ever seem that you were disputing that this should be apportioned pursuant to the CCR. As a matter of fact, that was your argument, is that this is not a fault, we should each be paying for it, right?
Right, and we had an expert that gave a sequencing of what the cost would be under this theory, that theory, and the other theory.
There was never one that your expert said where Mrs. Hill should be paid 0.
Well, that issue, what the expert said is that that Mrs. Hill didn't commit tort and didn't breach the contract, but they never went to the issue of should she be awarded 0. That particular issue, that was never put to the expert.
Obviously, you can't tell us why the other side didn't request it, but I at least understand, I think, your position as to the jury instructions. But it seems to me, and I'll tip my hand to you a little bit, trial court got it right in saying that it's wrong to say you don't have to pay anything. That the CCNRs are clear, you should have had to pay something. So do you acknowledge, or do you disagree with that at this point?
Well, Your Honor, I've got a pretty high burden on a motion for new trial. And I'm not going to say that Judge Rogers got it wrong, but Judge Rogers wasn't the one who did the ruling on whether or not it should be for damages only or liability.
Right, and I make sure I'm clear, so I'm not trying to trip you up and ask you a question that's.
I'm not thinking you're trying to sneak up on me, Judge.
But the first ruling, you don't really argue with, you don't dispute Judge Rogers' ruling. You just dispute how Judge Palmer applied it later. Is that a fair characterization?
I have to say yes. I don't want to because I got defense verdicts. But realistically, I think you're right, Judge.
Okay.
It should be just, and think about what that means. We have an attentive jury here, 4-day trial, 27 jury questions. And they had the ruling correct. If we want to try how much it costs to repair, which is what apportionment is, that's a different issue. And that's all that should be retried. It makes it a much faster trial, a much easier trial, than having to go through all the liability evidence as well.
So in your mind, to be successful here today, we'd remand this for damages and apportionment only.
Yes, Judge.
Okay.
That's hard to say after getting the defense verdict.
I get it. I get it.
And nobody wants to retry it. I know he doesn't want to retry it. I don't want to retry it. But let's get it to the issue that's really necessary to be decided. And that also takes a lot of the anguish between the parties away.
There was no, and maybe I should probably be asking your opponent this question, but there's no real issue no real legal basis upon which to find the jury verdicts as to fault are at issue.
There shouldn't be. There's plenty of evidence for that.
And Judge Rogers' ruling did not specifically touch upon that aspect of it, just the damages.
I believe that's true, Your Honor, yes. I don't have anything else.
Okay.
I just seem to be done early tonight, and I saved
You got 9.5
9 minutes.
for rebuttal. It's wonderful. Go ahead, counsel.
Good morning, and may it please the court. My name is Robert Connolly, and I am the attorney for the plaintiffs in the underlying action who are appellees in this matter. Let me take this off.
It's your choice whether you want to leave it on or off.
If the court and staff are comfortable, I'll be happy to leave it off.
As long as you don't approach.
Yeah, okay.
That's right, Judge.
And I represent, I'm one of the attorneys for Terry and Janet Miller, who are, as I noted, the plaintiffs in the underlying matter. The court may have noticed some references to a third plaintiff that was in the underlying case, Sana Kaltuki, and she has now been dismissed from the litigation. But as my colleague, Mr. Andrews, noted, he does have a high burden, a high threshold with regard to this matter, insofar as this is an abuse of discretion appeal, and the court should not disturb the trial court's ruling granting a motion for a new trial following a jury verdict absent an abuse of discretion that affords this court wide latitude with regard to granting, with regard to the trial court's analysis, and the trial court's order should be affirmed unless the, quote, probative force of the evidence clearly demonstrates that the court's determination with regard to granting the new trial with regard to liability and damages was, quote, wrong or unjust. And it's our contention.
So, for the sake of argument, let's set aside the liability issue. Let's say that's set in stone. Jury verdict upheld, new trial not granted on just that portion. Don't you move forward and do damages and apportionment? Isn't that really what's at issue here at this point? Why did the trial court remand for liability when the jury clearly found that Ms. Hill was not liable?
Well, I believe that the trial court's determination was spelled out in its order insofar as, at least my interpretation, which is that the jury got the entire matter of liability so wrong that there was no basis to uphold the jury's determination with regard to the issue of liability. Indeed, remember that this is a case in which Ms. Hill conceded throughout the litigation and throughout the trial that the wall was damaged.
Yeah, but you guys, neither side, and I'll point fingers at both of you, offered the jury a verdict that would allow them to do that.
Well, it's our
So you only asked them, is she responsible for the damage to the wall solely? And the jury said no. So why is that the fault of the jury? How does that say they got everything so wrong?
It's our contention that with response to that question, that they should have at least apportioned her with 50% liability, insofar as that was utterly and completely undisputed throughout the pendency of the trial.
Where did you give the jury the option in the forms of verdict? That's what I don't understand. I know there is a form of verdict that you first have to find her guilty of breach of contract, then you can go and do this apportionment thing. But there's a prerequisite to entering into the percentage game. There was nowhere in the forms of verdict that said, if Ms. Hill is not responsible, the causal factor for the damages to the wall, then we want you to revert to the CC&R's determine damages and apportion it between the parties. Is there anywhere that was asked of the jury?
Your Honor, and perhaps it was not articulately crafted, but it's our...
Don't say articulately crafted. Every one of the verdict forms says, is she guilty in tort, or responsible in tort or contract? Yes or no. And only do you fill in the apportionment if it's yes. So how can we say that's an option to the jury to do anything else?
Your Honor, if the jury found that she had some responsibility and the Millers had no responsibility, she would be 100% responsible for the cost of repairing or replacing the wall.
We're talking about causation.
Right.
So if she were 100% at fault in damaging the wall, that would be true.
Right.
The jury said she wasn't.
Right.
Did they not?
The jury said that there was no fault of anybody, despite the evidence, which indicated...
Well, the issue is a little bit different. I thought the issue that went to the jury was, is Ms. Hill at fault? Not, are the Millers at fault? They were only deciding if Ms. Hill was at fault. And they said Ms. Hill is not at fault. Right?
Your Honor, respectfully, I would counter that a little bit insofar as the defendant in the case was more than free to assert claims that the Millers caused or contributed.
Right. And she didn't.
That's correct.
Right.
But she didn't dispute that she was equally responsible or that she had a 50% apportionment, which the jury simply overlooked.
Okay, so you claimed she was guilty of tort, she was guilty of, or responsible for committing a tort and breaching the CC&R contracts.
Correct.
Where did you allege in your complaint or otherwise that if neither of those are true, she is responsible for her portion under the contract of the damage repair cost of the wall?
As a threshold matter, and this is spelled out in our responsive brief, the matter was litigated. So I believe under Rule 15b2, it's something that survives irrespective.
So it wasn't pled, but it was argued at trial.
Correct.
Is that correct?
Correct.
That's
But
your
you didn't
position?
present them with a verdict form that allowed them to do that.
Again, Your Honor, it was our contention that the verdict form would do that insofar as it did apportion.
Read to me where it would do that.
Okay. There is a verdict form referenced on page 7 of defendant's opening brief, which provides an allocation as between the parties with regard to fault. And as the court is aware, it's our position that essentially the range of fault that Ms. Hill could encumber in this case is either 50% on her best day or 100% fault and apportionment of liability.
And maybe I'm mistaken, but doesn't that cited verdict form say if you find her guilty of breach of contract or tort, you can then apportion fault? And the jury found she had not breached the contract or committed the tort, right?
The jury found that nobody did, despite the evidence.
You keep saying nobody did.
Right.
They weren't asked about your client. So the jury did not find that your client didn't commit the tort. They just found that she did not commit the tort, right?
Well, respectfully, Your Honor, the jury verdicts did inquire as to any exposure or liability as to the Miller plaintiffs.
There was a verdict form that says they are not guilty.
That's correct, or they don't bear any apportionment with regard to the damages.
only after you found the defendant Shirley Hill at fault for the injuries. That's the only way they would ever get to that apportionment part of your jury form. And if we're this confused and we are going round in circles, clearly the jury didn't understand that you were asking them also to say, well, if she didn't breach the contract, she's not committed a tort, you have to then go under the CC&Rs. You would agree, you never asked them to do that.
With regard to the verdict forms,
Yes.
we didn't precisely use language that would encompass what Your Honor is saying. That's correct.
Okay. Did you even include an option for them to find no one at fault and apportion?
I don't believe we did. We just set percentages as relating to the parties in the case.
And you didn't ask for a finding of damages independent of the breach of contract and the tort claim, is that correct?
We asked for a finding of damages with regard to the presentation of our case and presented the issue of damages for the replacement of the wall. And then relied upon the jury with respect to apportioning various percentages between the parties as to fault issues. Our contention was throughout the case, and it was undisputed, and the jury, it's our position, rejected the evidence, the undisputed evidence that Ms. Hill acknowledged that she was at least 50% responsible for this wall. We reiterated that point throughout the trial, as the court is aware from our responsive brief. We mentioned the issue of the CC&Rs applying, and that Ms. Hill, at a minimum, has a 50% obligation to contribute to the repairs to the wall on every day of the trial, the 4-day trial at issue in this matter. We also argued, in addition to that, that while she may rest on her position that it is only a 50% allocation of fault, our position is, additionally, that she is 100% responsible for the damages associated with the wall.
The jury rejected your claim that she's 100% responsible. If we revert to the CC&Rs, did your clients ever say, we'll pay for half, you pay for half, let's get this wall fixed?
They contacted Ms. Hill before litigation. I don't believe the correspondence back and forth before attorneys got involved got that granular. There was an effort to just get something resolved with regard to the wall, and they found no cooperation from Ms. Hill at that time, so this matter went to litigation.
And is there a big dispute remaining over the cost of repairing the wall?
There
Just
is.
out of curiosity, what's that difference, dollar amount? It's the trial judge and me coming out. Sorry, I just need to know.
That's all right. Our position, speaking in rough numbers, and perhaps Mr. Andrews can correct me with specifics, but speaking in rough numbers, it is the position of the Millers as plaintiffs that the wall needs to be replaced. And so their claim was several $100,000s to replace the wall, whereas the defendant's position was acknowledging that there is damage to the wall, that damage could be repaired and remediated on essentially a spot-by-spot basis. And so those repairs would be significantly less than, I believe, $100,000.
It's a cinder block wall, right?
It is, concrete masonry unit wall. The bottom, I want to say 7 layers are also retaining wall insofar as the hill property is elevated higher than the surrounding properties.
Let me change course just
Sure.
a little bit here. Isn't it easily severable or separable, I think is the word that the rule uses, but can't we easily separate damages from the issue of causation or liability? Isn't that, if this is going back, isn't that the more appropriate outcome here, is to kick it back for a trial on damages? Why would we need to kick it back and give your client a second bite at the apple?
As a threshold issue, Your Honor, I don't think it'd be a second bite at the apple insofar as there was undisputed evidence which was rejected by the first jury. But it's our contention that the issue,
Undisputed evidence as to what?
as to the fact that Ms. Hill is at least on her.
Right, there was undisputed evidence of 50% liability. There
Right.
was very disputed evidence as to 100% liability. You
Right.
lost. Why do you get a second bite at the 100%? That's what his question was.
Thank you, Your Honor. So it's our position that the damages issues are inextricably linked to the issue of liability insofar as if she has singular liability, she's responsible for 100%.
But the jury said she wasn't. So now what you're left with is how do we fix this wall? How much is that going to cost? And who pays what percentage? So if we accept what the jury said, and you keep saying it was undisputed, well, the jury decided she was not 100% liable. Decided. What's entitling your client to ask another jury to make the same decision? Because neither of you asked for the apportionment, neither of you asked for the jury verdict to say that the CC&Rs require apportionment and damages. Neither of you asked for a damage amount. So the jury did exactly what you asked it to do. To reset that and let you go after liability again, is she 100% responsible, is a second bite at the apple. Do you understand why we're all concerned about doing that portion again?
I do, Your Honor, yes. Our position can be summarized by what the trial court stated in the order which is now under review, which is the verdict is unsupported by the undisputed evidence presented at trial and is contrary to law.
Undisputed evidence at trial, he does not identify. However, if we talk about what was undisputed is if she's not 100% liable, she doesn't dispute that she's liable for a portion. Would you agree with that statement?
Could you restate that?
Okay. What the court said, undisputed.
Right.
What is undisputed? The only part that is undisputed is Ms. Hill says, yeah, I've got to pay for my part of this broken wall that I bore no responsibility for breaking, but I own half of it or am responsible for half of it or some portion of it. That's undisputed. Would you agree?
I would.
Okay, so Ms. Hill isn't trying to shirk her responsibility on the CC&Rs. What we're talking about is the liability portion. If we remand this entire case for the liability portion, you get a second opportunity to try and convince a jury that she is guilty of breach of contract and has committed tort liability. Why would we give you two opportunities to do that when there is nothing that really undermines the jury's first decision?
I believe there is information that undermines the jury's decision.
Tell me what it is.
All right. If the jury truly was committed to following the law and the facts in this case, the jury would have gone to the next stage irrespective of its determination of liability as between the parties and formulated a proper damages.
You did not give them a
analysis.
jury verdict that would have allowed them to do that. Every one of your verdict forms says, find her guilty of tort or contract. Then you can apportion damages. That's what I'm, in my mind, both of you went all or nothing. You both went for the home run. I get that. That's a perfectly appropriate litigation strategy. Your clients wanted 100%, weren't willing to take 50%. I don't want to give either of you anything right now. I want to say, trial judge was wrong and we affirm the jury verdict and you walk away with nothing because that was the strategy you guys chose. You gave them a verdict form that only lets them choose either 100% or 0%. Trial judge disagreed. Trial judge said, well, the evidence was, and I get Rule 15, the evidence, the way this case was presented was it's either got to be 50% or 0%, and we messed up in not giving them the verdict forms. But why would we go back to the 100% again?
insofar as the jury's analysis with regard to the totality of the matter was so off, refusing even to apply a 50% threshold and then go to the issue of
But you
damages.
don't, at least as I read your briefs, you don't argue that there was not very much disputed and balanced evidence on the 100% liability. You don't argue that the jury's verdict was contrary to any reasonable interpretation of the facts and evidence on the 100% liability issue.
No, Your Honor, I think
And you didn't argue that really to the Superior Court
that
in your motion for new trial.
we led with the most prevailing and compelling argument, which is that the jury even rejected that which was undisputed before then.
And I think that's what we're all getting really hung up on,
Okay?
that which was before them. There's all kinds of things that happen during a trial, but at the end of it, you say, jury, these are the issues you must decide. And you do that by the jury instructions and by the forms of verdict. And the forms of verdict submitted and agreed to by the parties did not give them the option to bring into effect the undisputed issue. If she's not liable 100%, she's liable for a certain percentage. And you have to decide how much the damages are and how much each party needs to pay, both the Millers and the Hills. And nobody did that. So the jury decided that which was before it. They decided Ms. Hill was not guilty of a contract breach or tort. But then they had nothing else to decide because you didn't ask them to. That's the problem.
It's our contention that the jury instructions did try to harmonize the percentages of fault as between the parties and then expect the jury to go on to an analysis of damages so that the wall could be fixed in either a 50% or 100% scenario. I see I've used my time.
Thank
Thank you.
Thank you, counsel.
I'm not going to take 9 minutes unless you have questions. If this matter gets remanded, I think the guidance in Seed versus Staten, and is what you've been talking about all day, is separation of damages and liability. The jury decided on liability. The issue of damages have not been decided. It's either 0 or 50-50, basically. And one of you asked about what about damages? And there is a dispute on damages. This is not a large wall. I think it's 82 feet, and they're saying it's worth $200,000 to repair a masonry wall for $200,000. I don't think so. So there is a real dispute on damages. And that's the only issue that should go back to the trial court if the court so decides.
So as Judge Morse pointed out, you guys both went all in.
You're right. That's
You
what
both went all in. So if we simply affirm the lower court, what happens then?
You want a human answer or a lawyer answer, Judge?
Let's try both.
The human answer is neither Mr. Conley's client or mine are satisfied because the wall's not repaired. If it goes back legally, then there's a decision on how to repair the wall and it gets repaired.
All right, so if we affirm the lower court, then a new action must be filed in which we talk about determined damages and apportionment between the parties. Agreed?
Exactly, Your Honor.
So that gives a completely separate solution to the same problem. Which one do you think is better?
Again, as a trial lawyer, I always like to win, Judge. And you understand that.
Absolutely.
But as a lawyer who represents Ms. Hill, it's better to have the wall fixed. So that is out of her life.
Thank you.
So it's better to remand and let the court do a trial on damages, is what you're saying.
I hate to say that, Your Honor, but yes. Again, that's because Judge Morris is right. We were both in all the way. And It didn't go the way they wanted, and wanted to go the way we wanted, but the wall's still not fixed. There's lawyers, and then there's people. You got to work both of them, unfortunately, sometimes.
I appreciate your candor, counsel.
Thank you. I'm done, unless you have other questions.
Thank you. Council, we thank you for your arguments today. You've given us much to think about. We will take the matter under advisement and issue a ruling in due course, and we stand adjourned.
Thank you.